Good morning, friends. Today I am going to discuss with you hearing of criminal appeal in the Honorable Supreme Court of India. Friends, as per Rule 20 of the Supreme Court Rules 1213, from Rule 14 to 21, there is procedure specified for hearing criminal appeals. Order 14 says that each party who has entered appearance shall be entitled to 2 copies of the record for its own use. So, before hearing the appeal, this mandatory requirement is to be done by the parties. Rule 15 says, unless otherwise ordered by the court, the appeal shall be set down for hearing 30 days after the expiry of the time prescribed for entering appearance by the respondent. So, friends, if the respondent is not responding, then we have to wait for 30 days to proceed further. Order 16, Rule 16, further say that the provisions of the Rule 11 of Order 18 of the Service Rules shall apply so far as may be apply to the parties in which this order applies. So, friends, let us go through Order 18 and Rule 11 of the Supreme Court rules. It says that where the party is not represented by the advocate of his choice, the court may, in a proper case, direct the engagement of an advocate from the panel of Supreme Court Legal Service Committee or at the cost of state. The fee of the advocate engaged at the cost of state shall be as such as may from time to time be fixed by the Chief Justice unless otherwise directed by the court. After the hearing of the matter is over, the registrar, additional registrar, or the deputy registrar shall issue to the advocate whose were engaged at the cost of state a certificate in the prescribed form indicating therein the matter of the name of the said advocate and amount of fee payable to him. The state concerned shall pay the fees specified in the certificate issued under Subrule 2 to the advocate named therein within 3 months from the date of his presenting before it his claim for the fees supported by the certificate. If the fees are not paid within the period above said, the advocate shall be entitled to recover the same from the state concerned by enforcement of the certificate as an order as to the costs under the Supreme Court Decrees and Order Enforcement Order 1954. And the state includes union territory also. Friends, now if he is not represented by advocate, no advocate has been given to him for the justice of system. Now, after doing this legal formality, then Order 17 says, due notice shall be given to the accused where he is not represented on the date fixed for the hearing of the appeal. The accused person may be, if he so wishes, present his case by submitting his arguments in writing, and same shall be considered at the hearing of the appeal. It shall not be necessary for an accused person in custody to be produced before the court at the hearing unless the court thinks fit in the interest of justice to direct him to be produced to enable him to argue his case or for any other reason. Further, Rule 18 says that pending the disposal of an appeal, under the rules, the court may order that execution of the sentence or order appealed against be stayed on such terms as the court may think fit. Further, after the appeal has been disposed of, the registrar shall, with the utmost expedition, send a copy of the court judgment or order to the High Court or tribunal concerned, whatsoever the case may be. No security for costs shall be required to be deposited, as this is criminal proceeding, and no court fee, process fee, or such fee shall be charged, and an accused person shall not be required to pay copying charges except for copies other than the first. Except where specifically otherwise provided in the rule, the provisions of this order with necessary modification and adaptation shall apply to statutory appeals filed under any enabling act or provision. So, friends, this is the procedure for listening to criminal appeals. This is statically provided in the rules to follow this so that the end result of justice is maintained. That's all. This is short video. Be connected with me for further videos. Thank you all for watching.